All right, you may proceed.
Thank you. Jeff Avery on behalf of the appellants. This circuit has emphasized that summary adjudication for causation issues in a First Amendment retaliation case is generally inappropriate. And that's because cases like this involve lots of factual discrepancies, lots of factual disputes involving intent, retaliatory motive, and actually the events that occurred. This particular case involved the complete decimation of the union leadership at the Port Houston Fire Department. That included the termination of the president, the vice president, and the treasurer, the suspension of the secretary, the termination of the only battalion chief who was a member of the union, and the suspension of another union member. The magistrate judge in this case, in his report and recommendation, resolved several factual issues in favor of the defendants that I think largely misses that standard. In particular, the judge made two findings that I want to address first related to the breaks in the chain of causation for retaliation. First, the magistrate found that because the plaintiffs were the ones who initially initiated a human resources report, that it broke the chain of causation for the retaliation from the union-protected activity. This misses, I think, some important facts, particularly three of them, that show it actually is, as this circuit has mentioned, a breadcrumb towards retaliation, not a break in the chain. First, Chief Buck, who's the head of the fire department, a month before these reports, had a meeting with Robert Jones. In that particular meeting, he told Jones to go out and meet with a different training officer, Luke Beard. Jones has later testified in his deposition that he was manipulated and sent by Chief Buck to that meeting, meaning Jones actually attributes the causation, the initial moving force here, to be that action by Chief Buck to send him to that meeting. Then on the second point of that is looking at what was actually said prior to the HR report that caused the plaintiffs to go to the human resources. It involved a conversation between Robert Jones and another training officer, whereas testified by the plaintiffs in this case in their declaration, they overheard Robert Jones trying to influence another individual to make a false report against them so that they would be able to be promoted to different positions. And in particular, Robert Jones said Chief Buck would be receptive of those reports, which is directly consistent with the meeting prior. So ultimately, plaintiffs were able to beat Chief Buck and Robert Jones to the gun and get to human resources first and make their report, but the initial movement was by Chief Buck. And I think even more important, after that report, Chief Buck talks to Jones before HR communicates with him. Chief Buck then tells human resources, Chief Buck then redirects and re-steers the human resources investigation by telling human resources this is much bigger, broader than the issues that were initially raised by the plaintiffs, and instead involve significantly broader, and when he used the word, was shocking allegations by Robert Jones. So in essence...
Step back a little. The First Amendment protected speech is union advocacy in favor of a shift change.
Yes.
And that started as long ago as 2015.
Correct.
And these plaintiffs were pushing for it then, but after that, they all got pay raises and promotions.
Correct.
Does that cut against an inference of causation?
It does not here because when the pay shift actually went into place was it was announced October 2019 and went into place January 2020, which is right during the same time frame that this all occurred. So
it becomes effective in October 19, 2019?
It was announced October 19 and comes effect January.
Not fired until March of 2020.
They're actually fired July 2020, but the initial report is March 2020.
Okay, so what's the case that says that's sufficiently close in time?
Yes. So there's two cases I think that this circuit has addressed. First is Jordan v. Ector County, which talks about significantly long gaps between the initial protected act and the termination. In that case was an individual ran for political office and then years later was terminated when the employee thought they were going to run for political office again. The second issue involves...
...to run again, so a perspective.
Right. Right, and what I'm getting at, Your Honor, is that that's the same thing here as when the shift went into place, that is what aggravated Chief Buck. His response was to take these retaliatory steps because the shift went into place January 2020, which is only a few weeks before those meetings. And there is another case too, the Lafayette Independent School District case also deals with similar time gaps, and the court even notes, the circuit even notes that long gaps are not dispositive of disproving causation. Particularly, you need to look at the breadcrumbs of the retaliation, and that's what I believe is going on here. And I think one particularly important issue related to this HR report is at the same time that Chief Buck is telling HR these issues are much broader and shocking, he also tells Robert Jones, don't tell him I knew about any of this. Keep me out of it. And Jones does that. So in effect, at the same time that he's bringing these issues to HR saying they're going to be bad, he's able to hide his own knowledge and involvement, which is particularly important, I think, for showing causation. The second area I think that the district court incorrectly construed is he construed the claim that these plaintiffs were a cancer as the starting of this snowball. The cancer claim was simply evidence of animus. It was not actually the events that transpired that led to the chain of events. What I just told about the events leading from January to March and the meeting and Chief Buck's involvement and Chief Buck's email are the events that led to it. Him calling the plaintiffs a cancer was simply evidence that he did not like them and had animus towards them.
Or it was him seeing them as a cancer because they're hazing people, harassing people.
So, and certainly the jury can determine that, I agree, but in this case, the judge construed it in the light most favorable to the defendants, which was that that the cancer related to something different.
But is there anything in the record that ties it to their union activity?
The cancer claim. Simply the fact that he referred to every single union leader as a cancer. So there's not something direct.
Single union leader fight for the shift change.
Yes, yes.
There's evidence in the record that all of those who were terminated had some sort of involvement with fighting for the shift change. Each
of the plaintiffs in their declaration talked about they advocated as part of the union for it through the 2015 to 2019 period. And in addition, there's other evidence.
That seems clear about your Kozlowski and Hall. But you're saying when we look at the declarations of Roberts, Stallings, Jordan, Meador, it'll all say that Buck knew they were advocating for the shift change?
I don't know if it will explicitly, I do know that it won't explicitly say Buck knew. It will say that they advocated for it, and Buck knew who the union members were, knew who the union leaders were, certainly. He testified he knew who they were. And in addition, if you look at the record, it shows that these particular individuals were grouped together. When they were investigated, the 6 plaintiffs, who all happened to be the union leaders, were grouped in the same period. They called it Group 2 for investigations. And expressly, Human Resources told Buck, hey, we're worried we're going to tip off these 6 Group 2ers if they ask for union representation, if one of the prior group asked for union representation. There's no doubt that the record at least contains some evidence that Buck and Port of Houston knew that those 6 individuals were not just connected as associated together for the union, but also related to union representation during this investigation. I think another issue that I do want to answer as well is there is significant evidence of pretext. In this particular case, they were fired for the alleged findings of the investigator. Chief Buck was one of the decision makers who made that decision based on the information that came to him from that investigator. And counsel for the appellees in their brief mentioned that, well, we can rely on a third-party investigator. The problem here is that Chief Buck knew that investigation was incomplete and biased. He knew that because he was one of the reasons why it was incomplete and biased. He hid the fact that he knew Robert Jones' reports prior to the report to HR. He told Robert Jones, don't tell him I knew. Well, that's particularly important because Robert Jones testified that Chief Buck knew about many of the things that were going on, including significant other misconduct that he didn't address because he was told not to by the Port of Houston HR.
Why does that matter if the report itself is based on the plaintiff's admission of most of the horrific misconduct and harassment?
So first, I would say that only part of the findings are admitted. Particularly the more egregious conduct was not admitted. Issues related to the rookie radar prank where they put up aluminum foil and pretended that they were being calibrated. Yes, plaintiffs admitted that they engaged or knew about that. 3 of them did. But there is also evidence that many other people did know about it as well who were not investigated. It was only the union leaders who were investigated. And in particular, Jason Roberts, who was the battalion chief, was fired not because he participated in anything, but because as a supervisor, he didn't take action to stop it. Meanwhile, Chief Buck, who is Mr. Roberts' supervisor, also knew about misconduct. And he hid that he had that involvement. So in effect, when he's deciding, I'm terminating Battalion Chief Roberts for engaging in this conduct, Chief Buck committed the same type of supervisory misconduct that he's alleging is sufficient to justify a termination. And in addition, the pretext, I think, is particularly important here because the investigators, her investigation was biased as testified by a human resources expert, Kim Harris, but also it just didn't include sufficient evidence because Port of Houston Human Resources Director Roger Walter told Robert Jones only talk about the plaintiffs. That's his testimony at Record on Appeal 770. Jones said, I was told to limit it to just these issues. And as a result, he didn't bring up, hey, Chief Buck knew about this the whole time. He didn't bring up, I also told Chief Buck that people were stealing things and committing insurance fraud. He also didn't bring up, there's other derogatory comments going on, racist, homophobic comments that Chief Buck knew about before this investigation. So instead, and I think it's also important to note that Chief Buck was no longer a member of the union. He withdrew when he became a chief, as confirmed by the testimony of Stan Kozlowski. Again, there's factual issues as to what was actually said, but Stan Kozlowski has testified that Chief Buck withdrew his membership because he did not believe it would be appreciated by the upper management at the Port Houston. So in effect, there's differential treatment in itself by a decision maker, Chief Buck, who's punishing people for conduct that he himself committed, as confirmed both by Robert Jones, or as confirmed by Robert Jones.
Chief Buck also a decision maker involved in the decisions with regard to the promotions and pay raises?
I believe he was. He was at least part of that system during that time period. But that did occur prior to the shift change actually going through in January 2020. And Chief Buck had particular animus and a disdain for that shift change, which occurred in January 2020. Some of the other issues, too, I wanted to address is...
The report did not have any admissions by the plaintiffs as to the hazing of the individual for the war in military injury?
It had some related to name-calling only. There was a couple admissions related to name-calling of that particular individual. There was another admission about a cover letter that happened 6 or 7 years before that was a joke cover letter that Chief Buck knew about in 2016 or 17. And there was the admission related to the rookie radar and references in the report to other people at the Port Houston knowing about the rookie radar. But the more egregious conduct, the showing of genitalia or the mocking of genitalia, that was disputed. And ultimately, the investigator weighed, through her own investigation, weighed some of the credibility, the incomplete data that she had, and made a decision. Yet then, after the plaintiffs are terminated, when Robert Jones, being upset, applies for the job of Battalion Chief Roberts and doesn't get it, he then makes additional complaints against Chief Buck and all the other people that he didn't get to make complaints about before. And at that point, the Port hires the same investigative company, different investigator, but same investigative company, and they find Robert Jones this time to be completely not credible because the allegations being made at Chief Buck. I do want to address a couple other comments as well that are made that I think show retaliatory intent and show the chain of causation. Is first, there's evidence that they were worried about tipping off the union during the investigation. And I don't see how, I understand how cancer can be construed differently by a jury, but the phrase tip off has a particular nefarious intent, at least trying to entrap somebody. And that issue related directly to union representation. They also Port Houston cleared Chief Buck from the beginning of the case prior to an investigator even being involved by noting that this investigation is inside, not at the top. Chief Buck is the top. I think that's important, again, because Chief Buck hid his involvement and then was able to participate in the investigation. He even gave a timeline which included years of facts that he had concluded himself to the investigator for her review as part of it. He was able to steer it through incomplete data and biased information. They also flagged the union leaders to the investigator, which again, I'm not sure how that could possibly be relevant for a third-party investigator who's supposed to be independent to know who holds what position in the union, but that was flagged to her at the very beginning of the case, and as a result, she reached these conclusions, and Chief Buck was able to take action, which was his plan through the chain of events the entire time, and fire and suspend the plaintiffs. Thank you.
Thank you, Counsel. Mike?
May it please the court. As non-movements, the employees had to establish a fact dispute on their First Amendment retaliation claims based on their record evidence and reasonable inferences from it. They are entitled to reasonable inferences, not unsupported leaps, not speculation, not for the court to indulge assumptions in their favor where there is an absence of evidence in the record. They have not met their burden, and this court should affirm. Subject to the court's questions, I'll spend my argument time addressing the Mount Healthy defense, the employee's failure to prove pretext, including some of the arguments made just now, as well as in their reply brief about similarly situated individuals being treated differently, and then the problems with the employee's prima facie case, including causation, which was the basis of the district court's ruling.
For me, it would help if you start with the basis of the district court's ruling.
Absolutely, Your Honor. So on causation, and we heard about this just now from opposing counsel. There are cases that say causation in a First Amendment context is generally not amenable to summary judgment resolution when the employer's reasons are not controverted, or are controverted, excuse me. They are not controverted here. So the employees have never contested that they did engage in the hazing, the rookie radar. The employees have never contested that certain of them admitted to using a derogatory name against Mr. Jones, as the investigator found. They've offered no evidence that those things didn't happen. So the only evidence in the record is that they did do those things. In that situation, causation is appropriate on summary judgment. The points they are raising as to how there is pretext here all fail when you actually look at the record. And I'm not arguing that the record raises a factual dispute. I'm saying that when you actually look at the record, the reasonable inferences from it do not support what the plaintiffs are saying. So, for example, we could start with the cancer comment. The plaintiffs had said that the district court, the magistrate judge, made a finding that, well, the plaintiffs had said the cancer comment predated this, and actually it didn't. The employees are the ones who have said that. So they said it in their actual brief at page 2-3. They said, excuse me, one second. Appellee's control and steering, along with the timing of Buck's cancer comment, are sufficient to establish that the Union Leaders Association with the union was appellee's motivating factor for disciplining them. And they said it in the district court as well at record 510 and 519. So they set up the causation as this cancer comment and the timing of the cancer comment being important for causation. The problem is that in the record, the cancer comment occurred, if it did occur. Again, most of this testimony is coming from Robert Jones, who has since sued the board. That comment.
Some of Jones's statements, maybe the manipulation one would be hearsay, but if he's attributing a statement to Buck,
correct. I'm not saying that it's inadmissible hearsay, Your Honor. I'm saying I'm indulging that it's true because Jones has quite a lot of things in his deposition that we would debate the truth of, but for the purpose of summary judgment, I'm assuming it's true. And if it is true that Buck said it, what's also true is that Jones said Buck told him he said it after his interview with investigator Lauro, which was about the hazing and harassment. So there's simply nothing in the record to tie the cancer comment to union activity. In this way, this case is just like Correa versus Fisher, where the plaintiff was trying to say, well, I was terminated because I'm not loyal. The defendant's been saying I'm not loyal, and was trying to inject that the defendant was saying he wasn't politically loyal into the statement. And this court said that's an unsupported leap. There's nothing to suggest that your political loyalty is the issue here, as opposed to just the defendant doesn't like you. And that's exactly what we have here. They don't have anything to tie the cancer comment to union activity, other than the fact that they say, well, we're all in the union. Well, they all also were investigated for participating in the activity. And on that point, they raise some, what they say are similarly situated people who were treated differently, comparators, in their reply brief. There is no evidence in the record that the first individual, Jeremy Kimmich, was not in the union. In fact, he was in the union until 2020 when the union kicked him out for not paying his dues. So he's not a proper comparator because he is similarly situated to them in that he also engaged in the protected activity, yet they are saying he was treated differently from them. And this is the individual that Robert Jones said made racist comments, killed a bag of kittens, these sorts of things. This person was also in the union. So that doesn't support that they were treated differently because they were in the union. The other three, I'm sorry.
You're right. The union activities have been going on for years, and there didn't seem to be any hostility to that. But he's saying then it sort of crystallized, the union leadership crystallized in favor of the shift change.
Your Honor,
That's what Buck didn't want.
Your Honor, the evidence in the record is that it wasn't just union leadership crystallized in favor of the shift change. All the employees supported the shift change. Non-union employees supported the shift change as well. And in fact, after Chief Buck was comforted that it didn't create safety problems, he supported the shift change as well. He's the one who brought it to the port on the October 1st, 2019 meeting to have it approved to start on a probation basis in January 1 of 2020. So the union activity had been going on for a long period of time, and the other wrinkle on this case that makes it strange is that the port actually can't engage with the union legally under Texas law. So the union does things, but when the port is interacting with the union, it's not in a true union activity sense because the port can't enter collective bargaining agreements with the union. The union has no ability to actually force the port to do anything. And that wraps into one reason that while in a typical case where there was union activity that would just meet the First Amendment retaliation protected activity standard, this case is not so clear because what they were doing was actually perceived as just acting on behalf of employees because they could not act on behalf of the union vis-a-vis the port. On the other comparators, though, that they've raised, and this goes to my point about they're asking for inferences in their favor where there's an absence of evidence. The other three individuals, the record site that they provide, just has Jones saying, well, A shift got treated differently. He doesn't say non-union people got treated differently. He says A shift. And then the other three, aside from Jeremy Kimmich, Robert Jones never says what they did. The record's completely devoid of them doing anything bad. So there's no evidence that anyone who engaged in similar conduct to them but was not in the union got treated any differently. And so there are no similarly situated people treated differently here to support pretext. There's just no evidence of that. The next thing they argue for pretext on causation is that the investigation was insufficient and that a later investigation that occurred after these plaintiffs had been terminated or suspended involving different allegations Robert Jones made against different people somehow undermines what the first investigator did. And to be clear, they were different investigators with the same company, but different individuals. On the first point, which is the criticism of the investigation as supporting pretext, this court's precedent is clear under Biankowski and Brandt, cases we cited in our brief, that an employer does not have to reach the right decision in some abstract sense to have made a non-retaliatory decision. The employer just has to have not retaliated. So the plaintiffs can't meet their pretext burden just by criticizing the investigation. And here, it's hard to see how the investigation could have been so flawed when the investigator relied on admissions that the plaintiffs made and then also corroborating evidence. So there's been some back and forth on the admissions and what the plaintiffs admitted to, but it's also important that the investigator noted in her report she only substantiated allegations that Jones made when she had corroborating evidence. One of the corroborating witnesses that she relied on was a man named Dennis Andrejak, who came forward and substantiated much of what Jones was saying. He was also in the union. So there's union activity or union membership on both sides of everything that happened here, which belies any argument that it's Buck against the union. So Dennis Andrejak corroborated certain of these findings. And so the investigator wasn't just, picking a side that she liked or found more sympathetic. She looked for evidence to substantiate what Jones was saying. And the plaintiffs don't ever address that not only were there admissions, but there was corroborating evidence that the investigator relied on. Next, on the later investigation, what the plaintiffs are trying to do is essentially impose a burden on employers where they have to go back and revisit employment decisions based on things that happen later after someone's been terminated, or else the employer couldn't have performed a sufficient investigation.
When did the termination occur?
The terminations occurred in July of 2020.
The shift change was implemented in
October 1st of 2019 was when.
Did any of them get pay raises or promotions after the shift change?
I don't think in between that time period, Your Honor. We in our brief, we go through the different promotions that they got, but within that short time frame, I don't think so, other than Luke Beard, who's not in the case but is peripheral to it. He's the one that Jones supposedly was pressuring to raise a complaint against these individuals. He did receive a promotion during that time frame, and he was in the union. But he's not a defendant, or I'm sorry, he's not a plaintiff. But they had been advocating for this shift change since 2015, and they'd certainly received promotions since then. So it had been 4 years of them raising this over and over, and eventually it became popular not just within them, but all of the port employees generally, because it was getting adopted throughout fire departments in the Houston area and even within the state. So
I would say too long a period of time between the event that the alleged protective speech and the ultimate termination, plus inconsistencies in terms of promotion and pay for the very people that were arguing. But their counter-argument of these comments made by Mr. Buck, the cancer comment, and then the Jones whole set of allegations that he was, don't tip off the union and that, so.
Yes, I'll speak to that, Your Honor. So on their trail of breadcrumbs theory, which I think is what Your Honor is referring to, so the Buck cancer comment can't be the initial trail for the breadcrumbs because it occurred in April of 2020. So that there's still too long of a gap there. The plaintiffs have also brought up that Buck left the union because he, and this is according to Kozlowski, he felt upper management wouldn't appreciate it. The record indicates that comment, if it occurred, I'm assuming it did for sake of summary judgment, would have occurred 8 years prior to this, because Buck testified he left the union before he became chief, well before he became chief, and he had been chief for 8 years at the time this happened. And that's at their record on appeal 697 to 98. So that comment can't be part of the trail of breadcrumbs because it happened 8 years before any of this, which is very remote in time. I'll just note on that point, none of this has to do with Marcus Woodring, for example. So if that particular comment Buck made about why he left the union or what Kozlowski perceived him to be leaving the union for doesn't have anything to do with Marcus Woodring. But it's far too remote in time to be part of this chronology from the protected activity to when they were when they faced adverse action. And then Your Honor also brought up the comments about tipping our hand. I think it's important that not one of these emails was written by Buck. So the plaintiffs keep arguing that these emails prove Buck's plan, but Buck didn't write them, and the plaintiffs have never argued or offered any evidence that Buck somehow also controlled, like Aaliyah O'Neill, who wrote one of them, or Roger Walter, who's the one who said, I think we need a deeper dive. And this was after Roger Walter had interviewed Robert Jones and was learning, he's got a lot more to say than just, he's worried about Luke Beard. He wants to talk about things that had happened to him years prior. So none of that is actual evidence of Buck having animus, and this gets to my point about they're entitled to reasonable inferences, not speculation. So there's just nothing to tie Buck to any of that. And further, when you read the emails, what they are concerned about is the integrity of the investigation. So the groupings had been set because there were two different competing allegations, right? The plaintiffs had made allegations against Jones. Jones had made allegations against them. And so there were witness groups in that order. And the outside investigator was and the port, HR, was concerned about witnesses being able to sit in on other witnesses' interviews. And that was coming up because some people wanted union representation in their interviews. And the plaintiffs were the union reps some people wanted, but they were also witnesses or subjects to the investigation. And so the concern was, we can't have someone sitting in on another witness's interview because they're there as a union rep. We need to figure out some way around that, or some way to make sure that witnesses are still giving, unbiased testimony answers to the investigators' questions, and they're not being influenced because they've been allowed to sit in on others' interviews. So on causation, a couple other points on the record. The idea of Buck's involvement, the plaintiffs are supporting that theory by arguing that Buck manipulated Jones by saying, Jones, you'll be allowed to apply for this captain position if you go pressure Luke Beard to make a false complaint. And in their brief at page 10, they suggest that this conversation where Buck said you can apply to a captain position would have occurred around the same time frame as this March 2020 meeting. And they cite the record at Record on Appeal 707. If you actually look at the record there, though, Buck clearly testifies that he told Jones he could apply to a captain position just like everyone else, that being a training officer wouldn't preclude him from doing that. So that there was nothing untoward about that promise. More importantly, that happened before Jones became a training officer, months before. And Jones became a training officer in late December 2019 or January 2020. So this quid pro quo story they have completely falls apart because according to the record, Buck did not say any of that in March 2020. And it's Buck describes he wrote in an email because Robert Jones was concerned he'd be precluded from applying to this position later. And so Buck wrote in an email months before Jones became a training officer that becoming a training officer wouldn't preclude him from doing that. So that can't have happened simultaneously with Jones Buck, supposedly sending Jones to instigate this false complaint. And finally, the cancer comment the plaintiffs have connected also with this idea that Buck then steered the investigation. The record is clear that Buck did not choose who to interview. There's no evidence he told the investigator what to ask or in what order to ask questions or in what order to interview witnesses. The only information they point to say that Buck influenced the investigation is Laura asking him station assignments, like who was at what station when. So just sort of timeline data that she could map onto what she was learning in interviews. An email exchange where they're just talking about setting up a call on May 20th and then the date when Luke Beard was promoted. So there's nothing in there where Buck is telling her you should look at this or you should look at that. And as far as the timeline he provided to her, this was a recap of what he had told her in the interview. And she interviewed whoever she wanted. So they don't have any evidence that somehow Buck had an outsized influence on her investigation than any other witness that she interviewed. The last thing I'll say on the causation issue, they relied on the fact that Jones says, supposedly, Buck told him, don't say anything that I was involved in this. And that's Record on Appeal 738 and 739. What Jones is actually saying at that record site is that he's not referring to Buck's involvement in this scheme. He's referring to the fact that earlier, when he'd asked for a transfer because he was unhappy at the station where he's being harassed. Yes.
My question is, and that's based on what's actually said. That's not some interpretation of what was said. You're just looking at what's actually being said.
Correct.
The longer I listen, the harder it is for me to find that there isn't some genuine issue of material fact, because I keep hearing all these facts.
And
We're here on a summary judgment.
And I understand that, Your Honor, and I am concerned about the fact that as I try to explain what the record says, it sounds like I'm saying there's a fact dispute. And what I'm trying to be clear on is I'm not saying there's a fact dispute. What I'm trying to show the court is that the evidence in the record does not say what they say it says. And that's at the record 73839. On Your Honor's point, though, last point as I'm running out of time, none of this is an issue if the court focuses on the Mount Healthy defense. The court can assume everything they say is right on causation on the prima facie case because they do not challenge the Mount Healthy defense, and the pretext evidence they've offered, which was the comparators, and I've explained they are not proper comparators and don't show pretext, and is their attack on the investigation is also insufficient. So even if the court wants to indulge their version of the record, it does not get them reversal. Thank you.
Thank you, counsel. Rebuttal.
Thank you. I want to start with the last point about the Mount Healthy and pretext and comparators. I think pretty bluntly, I want to say is Chief Buck himself is a comparator. He was not in the union. He quit the union. That's an undisputed fact. The evidence shows he had knowledge of these exact bad conduct going on at the same time that he terminated Battalion Chief Roberts for allegedly having knowledge of being a supervisor and not taking action about bad conduct. Robert Jones testified, I told Chief Buck about this insurance fraud issue. I told Chief Buck about the racist, derogatory, homophobic comments by Jeremy Kimmich. Chief Buck was able to hide that fact from the investigator. It did not come out. In addition, the HR director, Roger Walter, told Jones, don't talk about anything but your allegations to the plaintiff, to the investigator. So as a result, when Chief Buck is making the decision in July 2020, that he's gonna rely on this investigator report, he knows that it's incomplete. He knows that it was biased, and he knows that he committed the very same conduct that he is terminating Jason Roberts for, being a supervisor and failing to discipline employees for engaging in derogatory comments or engaging in misconduct. So that is a direct comparator right there. There isn't evidence that some of the other individuals...
Comparator who's treated differently by whom?
It was treated differently by Chief Buck because he was the one and the team, Marcus Woodring and the other individual who engaged in the decision.
Chief Buck is the one responsible for the termination.
Right.
So he should have resigned along with everybody else.
Yes, or Mark...
That's not what you're saying, is it?
I'm not saying that. I'm saying is that's evidence of pretext. That's evidence that they were going after the plaintiffs for something that one of the decision makers himself committed.
Evidence that he protected himself. I don't understand how that's evidence of pretext.
It's evidence of selective enforcement of a policy and hiding and manipulating a report, which they claim is the basis for the termination. If the report was legitimate and would have investigated these things, they could have made a decision, is this legitimate information that should justify termination or not for everybody, not just the 6 union members. What they did is they, rather than investigate the totality of misconduct, they limited it to the 6 union officers and members, not Buck, not the other individuals who were Buck's friends who engaged in misconduct. So they used...
Buck was making the termination decisions, wasn't he?
Along with 2 other individuals, yes.
I just don't know how you get to use him as a comparator, but go ahead.
Well, regardless of that, and as well as the beginning of the case, the Port of Houston cleared Buck in an email. So they allowed him to participate in the decision when he should have never been able to. I agree with that. Another thing that... The
investigation into hazing start. Who made the original complaint? Wasn't it one of the plaintiffs?
The plaintiffs brought the issue to HR, but the...
And he commences an investigation into hazing, and then, I mean, the argument is that the plaintiffs themselves admit to some level of hazing, and then they get fired.
The issue, though, is that first Chief Buck knew about it before the hazing, knew about this Jones issue, and sent them to that, and that Chief Buck had told Jones he would be receptive to a false complaint against them. But in addition to that is the way that the investigation was steered. And again, some of the issues are disputed. I think particularly the egregious conduct is disputed in the report. It contained an incomplete and biased investigation that was used to go after them. I'm not saying there wasn't rampant misconduct in Port of Houston. There clearly was, based on some of the admissions and some of the testimony of Jones, which flagged a slew of other issues not involving the plaintiffs, including racist, homophobic comments. What I am saying is that they used this information to target them and get rid of them while avoiding the entirety of the other misconduct, and as a result, sidestepped that and targeted the union. Thank you.
Thank you, counsel. The court will take this matter under advisement. That concludes the matters that are on today's docket for oral argument. We are adjourned.